Ocala's information station, 1370 WOCA.
Ocala.
All right, 25 minutes before 11 o'clock. Let's see, it is 30 minutes into the spring. Just 35 minutes ago, it was still winter. Now it's spring. John Fuller is in the studio. He's here not to talk about the seasons, but to answer your questions about legal issues that you might be facing. The show is called Legally Yours, and he, of course, is an attorney at the law firm of Fuller and Fuller. The other Fuller, I'm not sure who's first and who's second, but it's Janet. Janet's the other Fuller, and he and his wife help represent people in all sorts of cases. I know that John has said many times he's a trial attorney. Did I say that right?
That is correct.
A trial attorney. That's got to be, wow, what a roller coaster that must be. And Janet specializes in Social Security?
Social Security disability work,
okay.
And we handle litigation cases in business, commercial litigation, accident or injury cases, and complex family law matters. Good morning, Larry, and
good morning, John.
Happy first day of spring. And I think it's a wonderful topic of discussion to discuss the springtime weather.
Yes.
If anybody has spring fever, I can sympathize with it, because I feel like I may be getting a touch of that myself.
Yeah. The phone number to call, if you'd like to call, the number that I just called sounded like it was a fax machine, so we'll just ignore that one. The WOCA Climate Control Source Hotline is 622-9622. You can ask John a question. Can I start with one?
Absolutely. You're always the first.
What is the, you know what, there was a story this morning about a law that was made in the 80s regarding computer fraud and computer hacking and all that. And because in the 80s, the big fear was, breaking into the military, breaking into big banks, and so these penalties are huge. Nowadays, a kid hacks into, his school computer, and he gets the answers to his test, and he's subjected to possibly like 35 years in prison was one of the sentences, and a big dollar amount. Now, it sounds like there's common sense applied to this, but the prosecutors use this as leverage for the plea deal. And then they ultimately get a 43-month sentence. I think one kid got, after the plea deal, from 35 years down to 43 months. What is plea bargaining? Is that really a good tool?
Well, it is a good tool, but like any other tool and any other system, it's subject to abuse. And if it's only as good as the people who are involved with it. And I think that there are certainly cases where plea bargaining, or more appropriately maybe in this case what is called charge bargaining, is perhaps misused or overzealously used by an overzealous prosecutor. One of the things that we've seen is that there are a lot of abuses with sentencing that has evolved from well-intentioned legislation.
Yeah.
There have been a number of laws that have made certain sentences mandatory minimums. It takes away the discretionary authority of the sentencing judge, and if the defendant is convicted of one of these offenses, and there are many of them even without mandatory minimum sentences under the former federal sentencing guidelines, which were ultimately held inappropriate by the court, although the court said that judges could still use them as instructional information. But you used to have, under these what I consider rather draconian drug laws, especially at the federal level, sentencing guidelines. The statute would say a large sentencing range, but then the guidelines would put a young man who was perhaps a first offender in jail for substantially more time than someone who may have at the state court level committed manslaughter or something like that.
Right.
It lost all proportionality, and the judge's hands became tied somewhat, because in order to depart from these sentencing guidelines that used to be in effect in federal court, they would have to make specific findings of fact, finding sufficient mitigating evidence to justify the departure downward. And if they didn't have that and weren't able to make it a finding of fact, the appellate court would reverse if they departed from the guidelines. And you had these young people who had first-time offenders involving drugs having outrageous sentences. And, you know, we have minimum mandatory sentences in a variety of cases. Yeah. And so what happens is, you are absolutely right. It occurs all the time, is the prosecutor will charge someone with an offense that carries a mandatory jail sentence. Even if it's a case that is somewhat factually weak, and the chances of proving it beyond and to the exclusion of every reasonable doubt is uncertain, but nothing is guaranteed.
Right.
So the defendant finds himself or herself in a dilemma. Do they roll the dice with a jury trial, which is always somewhat of a crapshoot, because no one can predict what a jury will do. And if you roll the dice and lose, the judge's hands are tied. And you have to go to jail for this outrageous mandatory minimum jail sentence. So they will try to either charge a more excessive offense, or charge multiple offenses, where if you get convicted on them, the more you have, the more your sentencing guidelines go up. And then they will come in and charge bargain and say, well, we will, and the judge is not even a part of these negotiations. He doesn't have any discretion over what charge is filed by the prosecuting authority. So if the prosecuting authority charges 10 counts and then offers to dismiss 9 of them if you plead to 1, if you or go to trial for 10, which you've got to prepare defenses, which is very expensive for 10 charges, they leverage it that way. Judges are only involved in plea bargaining that involves a particular potential plea to a potential offense, and what the sentence might be, assuming there was no mandatory minimum sentence, and looking at what factors may mitigate or aggravate the sentencing guidelines. So this happens, and that's the reality of our criminal justice system. One of the things that is important, the prosecutor, whether it be the local state attorney or the U.S. Attorney's Office acting through their assistants, they are the first judge and jury that a criminal case, when somebody is arrested, they're the first judge and jury to look at the case and try to determine what's a real offense, if there is one, what's a provable offense, and charge that. I will say that in most cases, generally you find prosecutors who are very well motivated, who are ethical in the carrying out of their duties.
Hope so, right?
and you know, the system works when it has good people in it. The system, like any other system, doesn't work when it has less than well motivated people, or maybe people who are just not knowledgeable or have not been trained properly, and they think it's appropriate to throw the book at every case and try to go for the maximum. You know, there's a lot of philosophy about it. Certainly from a standpoint of the victims of crimes, it's understandable. They want the perpetrator to get the maximum offense allowable, because they feel aggrieved, they've been hurt, their privacy's been invaded. So there's certainly a balancing on the other side of the equation. I happen to think, and I think there's a lot of lawyers, including prosecutors, who share this view, that minimum mandatory sentencing, which started out as a noble cause by the legislature, because you may have a liberal judge down in South Florida who would sentence someone to 6 months probation for an offense that if they were charged with the same offense in a more conservative jurisdiction, say in the Panhandle, the judge would put them in jail for 2 years. And so you had great disparity in sentencing that was reflective of the general standards of the climate of the area in which the case occurred.
Right.
And the legislature wanted, by having sentencing guidelines and the courts, to give some uniformity, so that if you were charged with possession of marijuana in the Panhandle, you had the same guidelines that the judge needed to follow as if you were charged for possession of marijuana in South Florida, which generally, and I'm not picking on any area of the state, but I think it's generally recognized that South Florida is more liberal, if you will, in their approach and attitude towards certain behavioral activities than someone who may be in a more conservative rural environment would be. So it was a good goal. Again, the best goal is to have good judges who are well trained, well experienced, who bring a clean slate to every case and judge it on the merits. This is especially true in the times that we live, with budgetary cuts, taxes, economy, all being of critical importance to the citizens of our community, of our state. And if you have a judge that puts everybody in jail, the cost of keeping an inmate in jail is very expensive. I don't remember off the top of my head the numbers, but I've read them, and it costs the taxpayers of the state of Florida a lot of money for everybody who's incarcerated. Jails that are overcrowded require building new jails. That requires tax dollars. Would you rather spend those tax dollars on building schools and hospitals, or would you rather spend it on jails if there are other appropriate
really good
things?
Point. Yeah.
But it's a balancing act, because you don't want someone who is a hardened criminal who has long criminal record to let jail be a revolving door, so he gets back out in a short period of time and starts recommitting crimes against society and is a danger to society. So it's all a balancing act.
Do you know there was an episode of Bonanza going way back in TV, and in this episode,
what program?
The Bonanza.
Oh, okay.
Bonanza, and the Cartwright family was watching a man in a rowboat with wheels on it, and he was rowing his way across their land. There was no water on it, and he then claimed that he had a right to the land. And they said, well, you don't have a right to the land, this is ours. And he pulls out this legislation that said you can own any land you can row across. And so his intent was not to take their land from them, but rather to show a loophole in the legislation so that would be changed. Well, that was the argument of this kid who got sentenced on Monday, and Robin handed me the article so I could just tell you specifically. He was sentenced. He's 27 years old, so that, when I say kid, it just shows you that I'm not 27. He was sentenced to 41 months in prison in order to pay $73,000 in restitution to AT&T, because in 2010 he was trying to show AT&T they had a problem with their online security, and he was able to get the email addresses of people like Mayor Bloomberg. So that's what he's spending 43 months in prison and owes a lot of money because he's trying to show a loophole in the same way this guy in Bonanza was trying to show.
Right. Well, if you engage in social protest by intentionally violating a law, and we all know that ignorance of the law is no excuse.
That's right.
That's as simple as telling a law enforcement officer, gee whiz, officer, I thought it was a 65-mile-an-hour speed zone, not 35 miles an hour.
Right.
I didn't know that. That's not a good defense. And so, I understand, but I don't know. these laws, and the good thing about our laws is that they do evolve, and we do have the legislature who will amend laws that are bad or that are outdated, that they were designed when the only computers that existed were big mainframes that belonged to the Pentagon, belonged to NASA,
right.
and basically inherent in any breaching of that system entails some risk of national security, so forth and so on. I think that certainly one avenue that is always open to the citizenry when that happens is to contact their representatives, their legislatures, and to say, this law is 20 years old. The technology of our society, I mean, people didn't have cell phones back then.
Yeah, right.
People didn't have computers, it's to the extent
world,
that they do now. And so there needs to be a revisiting of these laws to make different degrees, where there are different degrees of internet violation, and I'm not familiar with this particular case or this particular law.
Right. Well, it was the plea bargain part of that I was curious about. If I came to you and I was charged with something, and I told you, look, I didn't do it, John, I'm absolutely innocent of it, and now you have a choice to either go to jury or have a plea bargain, even though I'm telling you I'm innocent.
Right.
It sounds like it's in my best interest to plea bargain because of the gamble you talked about earlier.
It is truly a very, very difficult choice that a citizen who's charged with a crime, let's remember, everybody is presumed innocent until proven guilty. And so a citizen who's arrested is just as innocent as someone who isn't. And we'll continue this. I see we have a call.
Yeah, and I apologize. There's somebody out there who thinks that our call-in number is a fax line. So it was ringing a lot. That's what you heard.
I see.
But I could hear that little beeping.
Right.
So I knew that it was a fax, and this doesn't have the beep. So I'm assuming this is a real person. Good morning. You're on there with John Fuller.
Yes, good morning, John.
Good morning, sir. How are you?
Very good, thank you. If you were a witness to an automobile accident, and okay, it happens, and let's say that you have an appointment that you have to go, you've seen the accident, and you cannot stick around and give out information because you've got to be somewhere. It's very important. If you leave, would you be getting in trouble, or could you, like, after you, let's say you had like a medical appointment that you couldn't miss or something, can you go to, like, let's say to the police department afterwards and say, I seen this accident on so-and-so corner, and not get in trouble, or how would that work out?
Well, I'm not sure I can give you a definitive answer of every scenario.
Yeah.
If it's a fender bender type thing, I don't think there's any law that requires a witness to stop and wait for law enforcement to show up and to offer that. Now, I'm not telling you this as a legal opinion because I've not researched it and I don't know specifically.
Okay.
I do know that if there is a witness if you're there and there is a serious bodily injury or possible death, I think there may very well be an obligation that you just can't leave there without making sure that law enforcement and the pararescue people are notified. I think that could subject you to some possible liability or criminal action. I don't know specifically off the top of my head. In any event, the best course of action is if there's no one seriously injured or possibly dead and you have to leave, after the fact, you may contact law enforcement, depending upon what jurisdiction, whether it's in the city or the county, and inform them that you were a witness. That is always very appreciated. I know it's very appreciated when I represent people who are in accident cases and have been hurt by a negligent driver. And I asked them, were there any witnesses? And they said, yeah, there were 3 people there, but they didn't give me their names, and they drove off, and I don't know how to reach them. It's very, very helpful. A lot of times I will have my investigator go to the scene of an accident and go to the neighborhood that's close by and knock on doors and ask people, did you happen to see the crash that occurred in close proximity to where you live at such and such a time?
Okay. If you were, let's say, a passenger in a car, and the car was in a minor accident, and the driver decided he's not going to wait around and he leaves the scene, are you liable then as a passenger being involved in it?
I don't think you could be criminally charged for leaving the scene of the accident if you're a passenger in the vehicle operated by somebody else.
But the guy who or the woman who drove away would be liable if somebody had gotten their license plate or something, and there would probably be a fine over and above the accident situation, right?
I think that's a possibility. I think there are statutes that require. I know in cases of serious bodily injury or death that there are. There's also a duty to stop and to exchange information and to call law enforcement.
You as a passenger would not be liable to
I have not researched that specific question, so I hesitate to give you a definitive, all-encompassing answer. But my expectation is that you as a passenger would not be criminally liable if the driver of the vehicle did not stop.
Okay, very good. Okay, thank you very much.
Yes. Larry, getting back to the topic that we were on about citizens who are charged with a serious offense, but they maintain their innocence, and there is certainly evidence that would support that they were not guilty.
Right.
And they have a right to a trial. But as we talked earlier, there is always inherent risk in a jury trial because no one can predict what a jury will do. Juries are made up of human beings. Human beings are not perfect. While I strongly believe that our system of criminal justice is the best system in the world, nobody contends that it's perfect. And innocent people do get convicted wrongfully in this country. We know that over and over by the Innocence Project that was developed by Barry Scheck in New York a number of years ago when DNA evidence became highly developed and highly reliable. And there were people who were convicted serving on death row sentences that were exonerated by DNA evidence and released from prison after many, many, many years. They were released. So we know that juries make mistakes. We know that the most inherently unreliable evidence that can be presented in a case is eyewitness identification. That is more flawed than almost any other form of evidence.
I bet it is.
But juries really believe that when somebody comes in and says, yes, I saw the person shoot the other person, and it's the defendant sitting there at the table. And we have had numerous psychological and sociological studies where eyewitness identification is the most unreliable percentage-wise testimony that can be offered, especially if the defendant is from a specific ethnic race, where for someone, not to use an insulting cliche, but they all look alike. We've heard that. Well, unfortunately, tragically, that's the perception a lot of times. Same thing with men who have facial hair. They are more defective eyewitness identification of men who have facial hair. I had a case that I defended of attempted murder a number of years ago, where the witness picked my client out of a photographic lineup and said that's the guy who drove by and shot into the dwelling or the structure. And they arrested my guy and charged him. And they had 3 photographs, and this eyewitness picked him out absolutely, unequivocally, no doubt in their mind. Fortunately, through our investigation, we were able to find out who the real perpetrator was. And he was already in jail.
Wow.
Now, what happened in this case that allowed me to be able to get this individual acquitted and the charge dropped was that the photographic identification did not show the height of the individual, just a photograph of his face. He had facial hair, and he was of a specific ethnic origin. The person who actually did it, who was in jail, looked enough like this guy to be his twin brother.
Wow.
Okay?
Wow.
The difference was my client was an exercise rider at one of the local horse farms. He was about 5 feet tall, and he weighed about 105 pounds soaking wet. The perpetrator who actually did it was about 6'2" and weighed 200 and something pounds.
Wow.
But they only showed in the photographic lineup the photograph of my client.
Gotcha.
And when we got the pictures and the description, and we asked the individual, how tall was the person you saw? Well, I don't know. Was he over 6 feet? Well, I would say probably. Did he look like a jockey like you see on television on the Kentucky Derby? Oh no, he wasn't like one of those little fellas.
Wow.
So you know, mistakes are made.
Yeah.
And so yeah, you know, if you were sentenced or you were charged with an offense that carried a long jail sentence, even if you're innocent, a lot of people will say, well, I'll take 2 years or whatever. I had a case where a young man adamantly maintained he was not guilty, and we had a lengthy 2-week jury trial that received major publicity by all the local media a few years ago. If he was convicted, he would have been facing a maximum sentence of 31 years in the state prison system.
My
and
goodness.
prior to the trial, a plea bargain was offered that was substantially less than that. And my client, which I have great admiration for him, he turned down the plea bargain.
Wow.
Where he would
because he knew
been,
he knew he was innocent.
Yes, but he also knew that if he was found guilty, he was looking at going to jail for 30 years.
Holy mackerel.
And coming out of jail somewhere, even with the guidelines, you have to serve 85% of your sentence. If he came out, he would have been in his 70s rather than coming out in his late 40s if he had taken the plea deal. And that was a huge, I pray that people don't ever have to make that decision. He made the decision. I didn't do it. I'm not guilty. I'm going to trial. It was a 2-week trial. The jury was out for about 2 hours and acquitted him on all counts. And the judge entered a judgment of acquittal on 2 of the 4 counts, which means that there wasn't enough evidence after the state rested its case for the jury to even consider it. It was a major case, and I empathized with the citizen who was charged, because it's a terrible choice, because there's a big difference. If you're found guilty and you're sentenced to 30 years and you have to do 85% of that 30 years, and you come out of prison when you're in your early 70s, that's a lot different of what's left with your life than if you take a plea bargain where you come out of prison even for a crime you didn't do in your late 40s or early 50s. That happens, and that's why I have unlimited admiration for the criminal defense lawyer. They are often despised and vilified, but the National Association of Criminal Defense Lawyers has a motto or a saying that I think really sums it up, that the criminal defense lawyer is liberty's last champion.
You're not kidding, and you are sharp, John, and you illustrate it quite frequently when you tell stories like that, and no wonder people go to you when they get into that situation.
Well, one thing is, having practiced law for 39 years, you can amass a lot of exposure and experiences to different types of cases, and sometimes they are instructive, I think. And I also think that's very important because it reflects the intimacies of human nature with people who are caught up in the system, whether they're the victim of a crime, whether they're wrongfully accused of a crime, whether they're the victim of a horrible accident, or whether they're the driver who may have inadvertently been negligent by some act of talking on the phone or tuning the radio, something like that. But the other party was equally at fault. You know, we have comparative negligence in Florida. That's another topic for another day.
It's good radio when you tell those stories, but thank goodness you were there for that guy and for so many of the other clients you've shared information. I apologize to the listeners. We weren't able to take your calls. We'll have to do it again next week. And, John, what's your phone number? Somebody needs to call you.
The phone number at the office is 352-547-4292. Our 800 number is 855-534-2565. The office of Fuller and Fuller. We have offices in Ocala and the Villages.
Call us here if you need that repeated. Go online and watch the videos that we've put up there on the YouTube channel for WOCA. You'll see lots of these shows that John has done. Every one of them has some, at least one spellbinding story that you've relayed to us that you've gone through. I will give you the article, by the way, about the computer fraud law.
Thank you, and thank to all our callers. Sorry if we got off on a tangent, but
it was a good one.
It was an interesting topic, and I appreciate you bringing it up, Larry.
We'll take a little break and be right back with Dr. Fakori.
Ocala's information station, 1370 WOCA.
Ocala. ABC News Now. I'm Karen Chase. Spring is just a cruel rumor to long-suffering New Englanders, digging out from the latest winter-like wallop of a snowstorm. The jet stream could keep the Northeast in the deep freeze for another week. The latest government numbers suggest autism may be more prevalent than suspected. New numbers show 1 in 50 kids is believed to fall somewhere in the autism spectrum, up from 1 in 88. However, some suspect the increase is caused by more awareness.